Thank you. Be seated. Good morning. Now is the time set for oral argument in cause number 1 CACV 18-0016. Village at Greyhawk Owners Association Plaintiff Appellee versus Catherine Marie Jones, Defendant Appellant. For everybody's information, we are recording both audio and video today, so it will be available and on YouTube in a couple of weeks if you want to get a copy of it or just watch what you were here for. Counsel, each side will be entitled to the normal 20 minutes. We would ask that you respect the time period. The timer on the podium will certainly let you know how much time you have left. And for the appellant's benefit, and I do recognize this is not your first time in the courtroom, sir, for the appellant's benefit, if you wish to reserve any portion of your 20 minutes for rebuttal, please let us know so we can avoid taking up all of your time. Ultimately, as you are well aware, the retaining of some amount of time for rebuttal will be up to you. For everybody's benefit, we have reviewed the briefs, conferenced the case this morning, so we are well aware of the facts and issues attendant to the argument. We tell you that so you can figure out how you want to use your time, how you can best use your time. Counsel, when each of you come to the podium, I would ask that you state your name and who you represent. And with that, Mr. Abney.
Good morning. May it please the Court. My name is David Abney. I'm here representing Catherine Jones. It's a difficult appeal, as most of my appeals seem to be these days. The difficulty is this is not just a pro per or pro se plaintiff saying, I'm a pro per, I need special treatment. Not at all. She's saying that because my lawyer was disbarred unexpectedly, I confronted difficult deadlines to meet in a case where I didn't have any case documents. My lawyer, I had given all the materials I had to my lawyer. I didn't have anything else relating to the case. I needed more time to get a new lawyer and to assemble the documents that I didn't have if I was going to try to defend myself.
I'm sorry. As I understand it, she had participated with her lawyer to the extent that requests were made by her lawyer. She provided him, her, whoever, with the materials that were requested in order to prep the case?
Yes, Your Honor.
Those had been timely given over to the other side or filed with the court, whatever was appropriate?
She was doing her job as a client and giving everything.
And had not retained anything for herself?
Correct.
And did not get copies back from the attorney that was ultimately disbarred?
That's correct, Your Honor. He did not give her the case file back.
So when we get to, I want to say March 6th, is that right? Is that the day that the court ordered the hearing?
The hearing was held, the first important hearing was March 24th, so I think it was set up around that time. But there was a notice of disbarment in early March.
And that's exactly what I wanted to get to. If we put it into that time frame, and we realize, I believe it's March 6th to March 24th is the period of time the court had once it had notice and before the hearing was set to be held, and there was to be a deposition in there too, I believe.
Well, there was to be a deposition set. Her lawyer was working on doing that, and she was not aware of what was going on as far as discovery.
How much time before March 6th did she know that she was going to need an attorney?
She didn't before March 6th. In fact, it took a while for any notice to get to her that her lawyer had been disbarred. It took a while to get to her.
From the time she had notice, there was 18 days until somebody had to be ready to give some responses and interact with the court.
Well, to appear at what was billed originally as a scheduling conference for March 24, which turned into far more, she had called on March 22nd and said, a couple times said, I can't come. I have medical issues, disabilities, and transportation problems with my husband, who also has medical issues and disabilities. And then again on March 24, in the morning before the hearing, she called again, got a hold of the judicial assistant and told the same thing, and then the judge was informed about that. And at the hearing, the judge went over this whole litany of calls that had been made and basically said it didn't matter.
My point being, she didn't have 60 days prior to March 6th that she had any knowledge, or 30 days prior.
Oh, no.
Okay.
She didn't have a clue.
And that's the time period.
Right. And I think the notice was filed on, I think it was March 6th or so, that the lawyer gave the notice that he was disbarred, and it just came out of the blue for her. But there's more to it than that. I mean, it's not just that she didn't have notice and she was out left on her own with no case file or anything else to help her, with no lawyer. She's disabled. She has severe medical problems, and she informed the court about that repeatedly. And the court basically said, "So what?" And I understand I think you've all been Superior Court judges, and I know some for a long time. And you've heard every "dog ate my homework" excuse you could possibly hear, and I assume a certain cynicism sets in at some point. But there was more here than the "dog ate my homework." This was severe problems. I was here October 22nd for an oral argument on the medical malpractice case that's been going on about some of these incredible problems that she's had, and she needed some reasonable accommodation. Now, whether you want to say reasonable accommodation under the ADA, which the Maricopa County Superior Court requires, it's got its own rule about that, or simply a reasonable accommodation as a trial judge. And you have people appear in front of you all the time that need the rules extended or bent a little bit.
When did your client file her handwritten stay motion?
The stay motion was 17 March, I think.
17 March,
sorry.
what year?
31 March of 2017.
And when was the default judgment entered?
The default judgment itself was after the default hearing in September 2017, but that was the commissioner doing that.
So how many months are between those?
A whole bunch.
Right. Did your client find a lawyer or even look for a lawyer?
She looked for a lawyer. It's not in the record, but she did look for a lawyer. The trouble is, by the time the judge said, "Well, I don't care about," back in March time frame, I don't care about these problems of yours. I'm not going to make even a telephone reasonable accommodation sort of thing. At that point, she was under duress. She was under punitive orders from the court, saying you've got to have a deposition by such and date. You got to have an inspection of the property for termites for such and such a date. And if you don't do it, I'm telling them you go ahead and apply for default. And so she was under the gun.
So if she's under the gun, we shouldn't be asking whether she's looking for counsel, or she shouldn't be expected to find a lawyer? Is that your argument?
She looked and could not find anybody willing to take a case under the gun for anything that she could have possibly afford to pay. As a lawyer, you look at this and you say to your client, "Well, what's scheduled?" And she says, "I've got this scheduled, and it's not good," and you're going to not find very many lawyers to take it. She had a horrible time trying to find a lawyer to take her appeal. In fact, I was the only one who stepped forward. So this is not a happy situation for a lawyer to step into, and it's not surprising she couldn't find anybody. So she tried to get things together to handle the case herself.
So if she had those 3 months,
right,
things would have been different. So a lawyer would have taken the case if there was a 3-month pause. Is that?
I think there would have been a heck of a lot better chance. A 3-month pause where nothing's going on. You got no punitive deadlines. You got no hearings scheduled. Nothing's going on at all. But you have the ability, 3 months to 4 months ability to get a lawyer on board. I think she would have had a lot better chance. And she never got the chance. And that's the whole point here. There's got to be some sort of reasonable accommodation going on here to allow litigants in this sort of terrible situation to go forward. It's not as if the world's going to come to a crashing end if a little extra time is given.
You keep saying reasonable accommodation, but I mean this boils down really to an abuse of discretion in your eyes, right? I mean, reasonable accommodation makes me nervous because I've never seen a case overlay the ADA onto the court's power over its own schedule. That doesn't mean that the court has unlimited power under its own schedule. The court can still abuse its discretion. So are you willing to concede that this is not really governed by federal law?
No.
You think
Although
it is?
I think there's two roads here that parallel each other. One is I think there's a general duty that all judges have in conducting their judicial business to make reasonable accommodations for litigants. But number two is the Americans with Disabilities Act applies to court proceedings, state court proceedings, and the Maricopa County Superior Court has adopted it.
Well, of course. I mean, it certainly applies to the way the court runs the courthouse. There's no question about that. But when it comes time to set a schedule for litigation. That our rules don't mention that at all, and the ADA has been around now almost 30 years. I've yet to see a case adopt that theory.
Well, I hope this case does, if there hasn't been one.
Well, I mean, there are certainly more direct routes to the relief you're seeking. But are you aware of any case that's done that?
Not offhand. I know there's been in fact, I wrote an article about this years and years ago about access to courts for litigants. I even cited it. Forgive me for doing that, but
So you didn't cite any authority to this court for that proposition, other than your article?
no, I cited other materials as well, other articles and cases dealing with the application of the ADA. So there's stuff, there's material in the brief to back this up.
I don't mean to be insensitive, but the real issue here isn't necessarily the disability. It's the fact that the lawyer was disbarred and your client was put in a very difficult position unexpectedly, really by an action of the court system itself in disbarring the lawyer.
Yes,
None of that is ADA material. That's judicial material.
No, and I don't blame the Supreme Court for disbarring.
I
I assume there
wasn't
was good
suggesting-
reason for doing it.
No, I wasn't suggesting they did the wrong thing, but I guess as I conceptualize your argument, it's more that the court system itself has a duty to avoid prejudicing litigants when it takes measures that affect their rights.
Well, there's that, but there's also, and I don't want to leave the ADA out the window
Well,
because
let's
I
do
think
that.
it matters.
Let's strip out the disability. Do you still have an argument here?
Yes, although it's much weaker.
But why, I mean, you're coloring your argument, or what?
No, well, gosh, let me see if I can address the question as I understand it. What you have here is not your typical pro per litigant left in the lurch by a lawyer who quits her. This is a pro per litigant left unexpectedly in the lurch by an attorney who's disbarred, and that pro per litigant has severe disabilities that would qualify her under the ADA or simply common decency to reasonable accommodations. And the ADA, as adopted by the Maricopa County Superior Court, they say the accommodations include reasonable accommodations in policies, practices, and procedures. So it isn't just making sure there's a ramp there or that you have assisted devices for hearing or any of the other things that you normally associate physically, structurally with the ADA. This is a matter of policies, practices, and procedures as well. If there hasn't been a case like this, there really ought to be, just to explain that the ADA applies here as well. A little extra time is not much to ask for.
This would be a pretty poor case, though, to use as a test case for that theory, I would think, because there's an extraordinary circumstance here, which is the lawyer getting disbarred right before the hearing. That seems to me almost a supervening cause. That doesn't happen much.
Well, it is an extraordinary circumstance. It is. I don't think I've known a lawyer who's been disbarred. I know it happens. I read about it now and then. It's just a shocking thing to me to hear about it. But the reason I bring in the disabilities and the ADA is because I owe a duty to my client to make all reasonable arguments on her behalf, and I think it's a reasonable argument to add into the mix here. It's an important argument.
Counsel, isn't there an additional consideration? You were talking about the fact that she attempted to find substitute counsel.
Yes, Your Honor.
I've sat a case or two, and isn't it true that there is concern among attorneys about buying into a malpractice claim? So even if the facts of the case themselves were simple, or even if the process of the case was not yet real complicated, that they themselves have to protect themselves in a late situation where they're stepping in for someone else?
Yes, that's true.
So are you aware of that being a concern, especially where you've got 18 days between the notice that you might be taking on a hearing without having seen the files and having to appear for something at the end of which you might be cited for malpractice?
I'm not aware of any lawyer telling her in this particular case that the reason I won't help you out is that I'm fearful of malpractice. However, based on my experience, which now is fairly long as a lawyer, lawyers don't like to pick up cases in midstream, much less toward the area where you're getting into hearings and possibility of the case exploding in your face. You simply don't want to pick it up if you don't have to. I pick up appeals a lot after they've exploded all over the place and do the best I can with them. But, I'll do it, but it's hard to do, and I'm reluctant to do it. But for trial lawyers, it's even worse. It's far
to
worse.
Suggest is that kind of exacerbates the issue of short deadlines and complexity
Honor.
of the case.
It makes it very hard, and this whole thing has been just very, very hard. And I'm not asking. I'd like to see nice, broad opinions that expand the rights of people, the consumers, and I love justice. As you know, big ideas of justice are wonderful. I'm not asking for that. It'd be nice if you do it, but I'm not asking for it. I'm just asking for this one particular client, on whatever narrow grounds you want to come up with, to justify it and support it, whether it's simply the disbarment or go forward with the reasonable accommodations. This one particular client needed more time. I just want to get her back in court with a little time to start this process over and have a chance to defend herself reasonably and with a reasonable, competent lawyer to do it. And if she can't find anybody else on the planet, I'll do it myself, even though I'm not the greatest trial lawyer in the world.
Or where you're making a record right now.
I am making a record, Your Honor. And speaking of records, if I'd like to reserve my time. All right, thank you.
Counsel?
Good morning, Your Honors. Joshua Boland and Timothy Butterfield on behalf of the Plaintiff Appellee, the Village of Greyhawk Owners Association. I think a lot of the things that were said here are exactly right. I think there's a lot of colorful language that's trying to paint this case into something that it's not. We're trying to look at the disbarred attorney and how that had an effect on this case. What we're not looking upon is the actions of Mrs. Jones and what led to the ultimate dismissal of her complaint and the sanction for that complaint. This case started back in 2014. This is an issue about a condominium complex. I don't know how familiar you are with condominium complexes. The condominium complex, under its governing documents, has an obligation to treat for termites and to make sure that its common elements, the buildings, the structures, are protected. In 2014, the association started doing termite treatments whenever this was discovered that there were termites up at the Village of Greyhawk Condominium Association. The condominium association then went to go treat it. In order to treat termites, they had to get into the garages. All the other unit owners besides Mrs. Jones allowed the association into its garages to perform this termite work.
I understand that, but you're basically arguing the merits of the case right now, and I think we have a preliminary issue, which is just whether the trial court conducted this proceeding in a manner reasonably calculated to offer justice to the litigants.
And I think that's great, and that's where I was trying to lead up to, and I could fast forward to what it was the injunction in this whole trial court lawsuit based off the need to get into the garage to inspect and treat for termites. After her attorney was disbarred, there was a large time frame that there was communication back and forth and trying to get in the garage to resolve the case. With a garage inspection, whatever it found could have ended this matter. So when her attorney was disbarred
couldn't
on
it
March...
also have ended the matter if your side had simply stipulated to give her a little bit more time to find a lawyer?
I believe we did, Your Honor. What we did is after March 6th, there was the disbarment letter. The March 24th hearing was set to be an evidentiary hearing for the injunction. Mm-hmm. What my firm did is change that to a scheduling order, voluntarily change it to a scheduling order to give more time to set the depositions. We needed the inspection to get into the unit to see what the unit was.
So when you say scheduling order, weren't there like two critical orders that the court entered at that hearing?
I wouldn't call them critical orders. What it was...
One was a deposition.
Correct.
And one was sort of what
the garage
lawsuit
inspection
was about. So I would call that big.
Correct.
And so that wasn't, I guess, the Village at Greyhawk sort of agreeing to a pause. It looks to me as if a proceeding, the court moved forward with a hearing that really awarded Greyhawk all the relief it wanted within weeks of your adversary having their lawyer disbarred.
I don't... No, that's not accurate, Your Honor. What it was there was a request to inspect under the discovery proceedings to see what the issues were. Whether or not an injunction would have been necessary, there still would have been a hearing down the road regarding the injunction itself. This was a part of the discovery dispute to inspect what was going on with the property to understand why we were being prevented from going in. The court did set two deadlines, an April 7th deadline for us to have the inspection and then for a deposition to take place after that. But the deposition was never going to be necessary, and as we've always stated, without understanding the inspection. The reason why the trial court got upset and dismissed this case was the blatant and willful disregard for the court's March 24th order allowing for there to be a reasonable inspection. This isn't a complex discovery dispute.
What relief did your client seek at the outset in the lawsuit? What did that relief?
The injunction actually to go in and treat for termites.
Okay, so that's the distinction, is treating versus inspecting.
That's correct.
Right, but you would agree with me that the court said go ahead and inspect at that first.
That's right, because the treating for termites may not even be necessary. We didn't know what extent, because this had gone on for years, we didn't know to what extent the termite treatment needed to happen. It could have been zero. We don't know. But what...
There must have been some way to have a little bit of a clue, unless I'm misconceiving the nature of this garage. Is it a standalone garage?
It's I believe it's on top of the units, or it's on the bottom of the units, Your Honor.
So is there a common wall?
There's the common wall between the common area and also the garage.
And your termite inspector couldn't have gotten some clue from the other side of the wall?
Well, we did have a clue that there was a big termite problem throughout the entire community because all the other garage units needed to be treated. This was the only standalone unit that didn't need to be treated. And we had red flags that was an issue. One, because getting back to the facts on the record in the evidentiary hearing, we had tried to get in there a number of times and were denied. We actually even at one point agreed to pay for a moving company to move her stuff out to allow us to do the treatments and move it back in. It was rejected prior to the lawsuit. We tried to do everything, but when we actually finally did have an inspection that Ms. Jones agreed to on April 5th, we show up and the walls and the structure and everything are covered by blue tarps that we're not allowed to move. And so we have an order from the court to conduct this discovery. We show up. There's a blatant and willful disregard, and that's what the court found in its minute entry at the later hearing conducted on June 30th, was that this is all about the willful and blatant discovery hiding and tactics by Mrs. Jones that led to this.
Now,
and at
counsel,
the March 24th...
Counsel, if I may, did she do that on advice of counsel?
Not that I know of, no, Your Honor.
Because she didn't have an attorney at that point.
I don't know. See, the problem is also Mrs. Jones on the March 24th scheduling conference said she wasn't going to show up. She didn't request an accommodation to appear by phone. She just said she wasn't going to show up.
I'm not sure that that's an undisputed fact. As I understand it, there was a request for a telephonic appearance. Am I wrong about that?
That was not my understanding of the record, Your Honor. I think that was the argument made in the appeal brief, but that was not what the record states. And also what we had then is also going back to don't forget in the June 20th, Mrs. Jones blatantly said after refusing to comply with the court's orders that they were no longer going to participate in this lawsuit. So finding counsel, doing whatever, the September hearing, she said she was done with it. What is the court supposed to do at that point? They made an argument that the court should have appointed a special master to resolve this discovery dispute or some lesser sanction. But at that point, because of the withdrawal and to her word, she did not show up at the hearing 8 days later or ever sought out counsel to our knowledge, the court had no choice. What was the court going to do? They could have gave us the relief. What we wanted was the injunction, which we ultimately got by imposing the discovery sanction. But no lesser sanction in this case would have made a difference.
Well, let's talk about the documents, okay? The only evidence in the record, if you want to call it that, is that the relevant documents were placed into the hands of her counsel at the outset of a lawsuit, which is standard fare. And we have a disbarment, and so you have an adversary who doesn't have a roadmap from which to make decisions on litigation. Was that considered at any point that putting aside whether or not she needs to find a lawyer, what about letting her have the same documents so you're all operating off the same record?
We would have been happy to provide her with the documents, Your Honor. The problem here was the blatant disregard and willful neglect to participate at all in the litigation.
Why not just send the documents?
The documents are public record. The only documents that we used in this case were the governing documents of the association and the prior letters that had been sent to her that she had received and the Termex quote of what needed to happen. These are all public record documents. This wasn't some highly factual, disputed
Public
case.
record, the termite, what was the last document?
The governing documents, the CC&Rs require it.
Let's say that's public. What was the other document?
That's it. That's all that's at issue here is the association's obligation.
Your 26-1, you only disclosed or identified, because disclosed,
Correct.
we agree there's a difference
Yes.
there. You only identified, if I were to pull up your 26-1, one document.
No, Your Honor, that's not true. All the letters that were sent to her are requests for access into her property. All the association's prior notices that were sent to her to allow
Those are
access.
not public record.
Those are not. That is correct.
So
Your Honor.
there was any amount of communication, whatever you want to call it, memos or whatever else that's there, that you didn't give them, that you had no reason to believe she did have, communication with her attorney.
We did have a reason to believe she did have it because her attorney was only brought in after the lawsuit was filed. All prior communications and everything had been happening with Mrs. Jones
Help
in the
me out
community.
with the timeline, though.
Please.
There's a moment when the notice of disbarment is filed.
Yes.
What orders before that date was she aware of and willfully failed to comply with? What court orders?
None at that time that I'm aware of.
So from the court's standpoint, here you go. You've got a hearing coming up. Lawyer is disbarred, and the court's first reaction is just to go into high gear and not reschedule anything. Just start imposing orders and sanctions. Does that strike you as odd?
I don't think that's what the court did here, Your Honor.
If the court, for example, had a track record of willful disobedience of orders before the disbarment, I would have a much easier time with what it did here.
Right.
But because it's looking at this case fresh,
Right.
I have a difficult time saying, as a former trial judge, yeah, that's what I'd do. And I know that's not the standard, but it's very far from what I think most trial judges would do.
But I don't think that's what happened here. I think there was a notice of disbarment on March 6th. And Mr. Wood, who was disbarred, represented a lot of homeowners and a lot of homeowner cases that we had against him. So we were very well aware of the issue of what was going on. So what we did is, again, unilaterally change the evidentiary hearing to scheduling conference because we were trying to get depositions set up. We were trying to get the inspection set up.
And
it was not happening.
I think that's a professional thing to do, and I'm not being at all critical of the steps you took. But even in response to your gentler approach, the court seemed rather bent on moving forward. Damn the torpedoes.
I don't think the court was intent on moving forward. I think the court wanted to keep the case going because I think the issue here is so simplistic and minor that I don't think the court wanted to waste its judicial efficiency and time to do that. It was.
They were on the 24th. I think you've already said that they set depositions. They as of the 24th. Ms. Jones was bound to depositions and some other discovery issues.
They were bound to have an inspection by April 7th. The depositions were to take place after the inspection.
So they had 2 weeks to get the inspection done. She has no counsel on this, and then the depositions were to be taken immediately after that, after the inspections.
We hadn't set the depositions at that point, Your Honor. We'd been trying to work with her to schedule a deposition, and the record will show that she'd made a number of requests to have different types of depositions because of her issue. The depositions never even got set or never was an issue because the inspection issue was never completed.
And counsel, I just want to be clear something. You're not arguing that your adversary is not entitled to counsel because it was a minor. You just characterized it. It was so minor that damn the torpedoes, full steam ahead.
No.
Is that your argument?
No, Your Honor.
That you're allowed to sort of stiff arm whatever representational rights you might have under a democracy if minor issues are at play?
No, Your Honor, but I think when looking at an abuse of discretion, I definitely think it's something that the trial court can consider. And I think it's definitely within the trial court's abuse of discretion and their discretion when having a blatant disregard to participate in discovery,
But there was
high
no blatant
discovery.
disregard. At the time of the scheduling conference that you rightly transformed into a scheduling conference, there was no disregard of anything. There was just a disbarred lawyer. Wouldn't the appropriate thing to do be to say, okay, we're going to have a scheduling conference. The lawyer is disbarred. When do you want to schedule this?
Right.
It would have been that simple.
Counsel, an abuse of discretion is issue-driven, right?
It is. It is. And I think that's what's here when you look at the blatant disregard. It's very easy to sit up here, as all of you are trial court judges. You know when someone's blatantly disavowing and failure to participating and hiding things.
But that's why I asked the question. If I knew, putting myself in that role, had I known that there was blatant disregard, that certainly would have colored my view. But here there was none. I mean, the case came in sort of a very clean posture, but for this very odd event of a disbarment.
I don't think that's the case, and I think what the ultimate sanction was levied was because there was the hiding of evidence and not allowing the garage to take place. I think we're looking at the 24th hearing as setting something. She voluntarily agreed to April 5th to allow us to come and do this. This was voluntarily complying with very preliminary, easy discovery. Open a garage, let people in to look at it, and leave. That was it. It's not that this complex discovery. And when there was a blatant disregard for that, and then followed up with that at the June 20th hearing of she was not going to participate and not allow the association to fulfill, she violated the court's order that this could be a possible sanction if it didn't happen.
I guess, yeah, it depends on what time you look at the case.
Right.
I mean, you have a much stronger argument that there was a disregard as time goes on. But
Right.
those orders were in part the product of rushing the case without any consideration of the circumstances that she found herself in.
I don't see it that way, Your Honor. And I see it as the way of the March 6th disbarment happened. There were plenty of times for her to hire a lawyer between March 6th and June 30th.
So let's talk about that. What is the significance of the fact that she did not hire a lawyer between the notice of disbarment and the default judgment?
I think the whole part is that she didn't do anything to participate in the lawsuit. Her
It's almost
admission.
as a matter of causation then, right? We can look at it as two different worlds, as if there's no disbarment and there is a disbarment.
Right.
Does she have, and then we in both instances, we have the current posture of the case, right? A default judgment and penalties. Can you say that the disbarment really was immaterial or irrelevant? We would have been here regardless?
I think so, Your Honor, yes. Because of getting back to the nucleus of the issue, I don't believe and that's the one thing that's been blatantly not here. What legal cause, besides not having representation, that which wasn't ever offered at the trial court part, what cause did they have legally not to participate in the inspection? And there's an evidentiary, if you look at the evidentiary hearing that took place and the evidence that was presented to the court, there is a clear picture to show that Mrs. Jones for years blatantly disregarded her contractual obligations under the governing documents, refused the court's order, refused to participate in discovery. Clearly, the court, in its own minute entry, talks about her willful and deceitful conduct to hide discovery. This was the only way of doing this. She could have hired a lawyer. We'd been happy to talk about this. My firm represents...
The form of discovery here was not just responding to an interrogatory. It wasn't the question, do you have termites? It was allowing people into your home, unrepresented, which I'm not suggesting for a moment that wasn't contractually required. But some people may require counsel to make that process go smoothly. I'm sure you're familiar with that.
Correct, Your Honor.
Right? You deal with these cases all the time.
All the time.
So, would the court not have been, whether or not it's an abuse of discretion, would you agree that the court might have been more prudent to set this off a little bit?
I don't think so, Your Honor.
Okay.
Given, I just have to be honest, given the years that had gone on, the amount of damage that could have been caused. Termites can cause a lot of damage. Again, this started in 2014. There was a judicial efficiency of requesting an injunction and trying to get this set quickly. That's why we request injunctions in this case. A preliminary injunction was to try to have a hearing to get this done to avoid further damage. And instead, we're continued to held at arm's length of what to do here. So could time always help anything? Yes, time could always help any case. But there's times where judges have to be able to use their discretion to say, time is of the essence here, and we need to move this case forward. Because the only thing that's going to do in fighting this case and continuing to litigate it today is raise the cost over a termite issue that is a few $100s. I mean, and so the judicial efficiency in looking at this case and how to resolve it, we can't just take the emotions and the looks of the trial court and the communications that they're receiving and just throw them away.
The fact that we're here today over a few $100s of termite spray does make the term judicial efficiency seem a little misplaced.
I 100% agree. And as someone who litigates a lot of non-judicial efficiency cases, I just want to get them in to see if there's termites. And still today, we don't have this. We could have avoided this appeal by making that request. But there's been just a disregard.
Done the inspection yet?
No,
And the house hasn't fallen down.
we don't know.
No sinkholes.
I don't know because I don't know what the inside of the garage looks like.
Counsel, you made a comment about the fact that the court had gone through an entire process, that this had been going on for a long time. There had been any number of things that had been directed. There had been no compliance by Ms. Jones, apparently, with any of it. The court had become very frustrated,
Right.
I think you said,
Yes.
by the time you got to the March 6th order and then the March 24th hearing.
The June 30th hearing, Your Honor.
June 30th. What had the court done previously? Had the court sanctioned with attorney's fees? Had the court ordered additional hearings to be set? What had the court done before we get to the point where the attorney is disbarred and all of a sudden she's unable to go forward and everything moves forward apace? What had the previous sanctions entailed?
Nothing at that point, Your Honor.
Okay, so
That's-
however bad it was that had the court frustrated, by the time you get to the June 30th whatever, it wasn't bad enough to ever do anything about it.
No, from March 6th to June 30th was. Prior to March 6th, there was nothing. But between March 6th and June 30th, yes, there had been notice from the court that they needed to comply or this could happen. That was able in a minute entry on March 24th. There was a contempt hearing. There was a number of continuances between that time to talk about this. We filed a motion for contempt. They filed a motion to dismiss, saying they were no longer going to participate. And we had a full evidentiary hearing on June 30th. This wasn't the court walked in and said, yes, you get your relief because I'm upset here. We put on evidence. We put on all the requirements and everything. The court, within its discretion, and I believe it's the Cannon case, found I'm sorry, correct that. The case here was the Wayne Cook case, that ultimately the sanction was warranted because there had been an obstruction of discovery by the plaintiff. Her attorney had not been involved. This was her willful acts. There was an evidentiary finding by the court, and the court found that no lesser sanction could hear. So the Wayne Cook case supports what the court did.
And that's between March 30th and, March 24th and June 30th?
March 6th and June 30th, yes, Your Honor.
So you're going back to when the court first found out. This is when it shifted over onto Ms. Jones' shoulders.
Correct.
All right, thank you.
Thank you very much, Your Honor.
Thank you.
Let me ask you something before you start. I understand your due process concerns, and if you were to be successful today, what's the point of relitigating this? Is there a legal defense here to a termite inspection?
Yes.
What is the defense?
Well, to delve into the merits a little bit, there was a dispute over who was going to pay for the termite inspection, how much the termite inspection would cost, who would do any termite remediation, how much that would cost. And as part of the inspection, the Joneses had some very large filing cabinets filled with Alan's work when he was a professional engineer that had to be moved. And not just
Offered to
moved,
hire
but stored.
movers.
Well, who's going to pay for that? There was a dispute about that as well. The moving, I think they were agreeable at one point to paying for that, but the storage would take 3 or 4 days, and they were not agreeable to that. And storing some very heavy concrete lined cabinets for several days is going to be expensive.
Well, I understand that those are practical concerns, but that's not a defense to the obligation to participate in the inspection, right? I mean, it seems to me fairly summary judgment worthy, not that we ever got there, but fairly summary judgment worthy to say, the documents say you got to allow an inspection. What's your defense to that?
Right.
What are you going to say? No, we don't have to allow an inspection, or we have to have everything arranged just the way we like it before it proceeds?
No, the defense would be, yes, there can be an inspection, but it has to be reasonable, and we have to work out who is going to pay for what, including for storage.
Is there ever an effort to do that?
There were a number of discussions before this exploded into litigation.
It seems hard to me to believe that we are here at the Court of Appeals in oral argument over moving some file cabinets, and that people couldn't have worked that out.
Well,
I mean, I have a hard time believing that counsel before us today are that unreasonable.
the Joneses tried to work it out with the association and were not able to do that. There was a long period of time trying to work it out, and they simply were at loggerheads over for instance, the inspection. The association wanted the entire garage completely cleaned out before there could be an inspection. What sense does that make?
I'm still coming back to this. Why is this case being litigated? If you're successful today, what do? Go back and litigate who's going to move the file cabinet and where in the garage it's going to go? Or are you just going to figure it out? I mean, does this case need to be litigated further?
I don't know if it needs to be litigated further or not. If we get back down at the trial court, we could probably settle it with some sort of reasonable accommodation. But if not, you can't settle it right now.
But why not? What's the difference? Let's say you lose today. There's still going to be an inspection, right? I mean, there are no substantial rights at risk. It's just inspecting for termites, folks.
There's more than that. The inspection is not just send somebody over and take a look around. They have to, at least if they keep holding on to their position, you got to empty the garage, you got to store the materials in the garage, you got to allow a full inspection, and then a treatment, and then there's still disputes over who's going to pay for all these various things that happen.
I just want to get something clear. In your answer to the complaint in the trial court, did you raise a defense that there's no such contractual right or obligation, or is that, I mean, we're not going to just jump to who pays, right? First we got to establish what the obligations are.
Right.
Are you saying that there's no question as to the obligations? It's just a matter of who's picking up the bill and moving things around?
Well, it's more than that. There's a right to an inspection, but it has to be done in a reasonable way, at a reasonable cost, and so forth. So it's all one thing. To separate it away and say you have a right to inspection,
let's take those in
and
turn.
you win.
Reasonable way and reasonable cost. Okay. So what reasonable cost is money, right?
Yes, Your Honor.
And reasonable way, what? Time
and effort.
How clean it has to be.
And inconvenience, certainly. All those
inconvenience, whether it's a Thursday or a weekend.
How long it lasts,
Okay.
sure.
What else is way?
Those are pretty much it.
So if we took a 10-minute recess right now, is there any reason this case couldn't just settle? I mean, somebody's got to inspect for the termites. There's really no argument about that. It's got to be reasonable. There are a few permutations. It would seem that hiring lawyers to litigate those issues in the Superior Court is a really poor use of your client's money.
Well, they were sued, so they had to defend themselves.
No, I understand that. But now that we're here, I'm just trying to determine why this case has a life of its own. I mean, your ultimate goal here is to get a remand, and even if you're successful, does that really benefit anybody?
There's no guarantee that their position will win. There is no guarantee that their position will lose on remand. But at least she will have a chance.
There is a guarantee that litigating it is about the worst way to arrange having somebody look at the wall in a garage that is humanly imaginable.
No. Self-help is the worst way, and that's why we have the common law in the courts, to make sure that this doesn't descend down to the level of primitive violence. I mean,
self-help might be worse, but the parties here did enter into a contract, and it's not really in dispute what that contract requires in broad strokes. We know it's going to happen.
In broad strokes, but it's the specifics that matter, which is why this litigation arose. They could not agree, and I know the idea of a recess
I was being somewhat hypothetical and hyperbolic when I suggested that, but it does seem to me that a 10-minute discussion between two reasonable counsel should result in the resolution of this case.
Well, I mean, if I may, without telling stories out of school, there have been efforts to try to settle this even at this stage, and they have failed. So the odds of settlement are poor. The odds.
Told that many times.
I know you have.
And I've
I know you
settled
all
a lot
have.
of cases.
But
And I'm not trying to mediate your case right now. I'm just suggesting to you that whatever the result of today's oral argument, I would urge everybody to try and use their client's money as wisely as possible.
absolutely, you are preaching to a one-man choir here. I agree with you 100% on all of that. But the difficulty is, if it goes back down in the present condition that they've lost, then there's this will be about as exciting as the negotiations in 1940 between the Germans and the French. I mean, there's not going to be a lot of negotiating going on. This is going to be a capitulation. I don't know if that's the best example of the world, because there was a Vichy France
I'm not
that
sure I would
existed.
go in that direction. But,
Okay, maybe not that direction. Maybe more like the Versailles Treaty in 1919. But the difficulty here is, I've got my one client who never got her day in court, and if there's I burned through my time. I apologize for that. There's one.
I burned through some of it for you.
It's a pleasure to have you do
Charge
it,
him.
but for
But
me,
it's interesting you say your day in court, because on reply, on rebuttal here, that's completely changed for me. The day in court here is not fighting about contractual obligations. It's fighting about time and who's paying for those obligations.
well, it's all connected. I mean, the part of any contract is, if there has been a disagreement about it, how do we resolve it? And in this case, it's going to be somebody's going to have to figure out who pays for what, how the inspection is done, how long it takes. All these other things have to be resolved in one fell swoop.
Counsel, won't you agree with me that if you sit down in an effort to try and settle these issues, recognizing the amount of money that's already been spent and the amount that's going to be spent if or when this matter goes down, that spending some time attempting to settle is probably going to be a better use of money than to I mean, we're not talking about rebuilding the trade towers here, okay? And it strikes me that a long time ago this thing went past the level of a reasonable cost to get this dispute resolved. And if nothing more, I would suggest to you that the parties sit down and take a serious look.
I would hazard a guess that if somebody handed both sides, counsel for both sides, a memo, the exact same memo, with the facts, the contract, and asked you for your evaluation of the case and where it was likely to come out, you'd come out within 2 millimeters of each other.
Possibly.
So, I mean,
And yet you're going to fight for the dollars over that. And
No,
they're
I'm
dollars
not
that could
going
be
to
spent
fight for
settling.
the dollars. I'm going to fight for my client's rights.
well, your client's due process rights are of independent significance, but I try to be conscious of the effect of what we do here. And if what we do here is just further disadvantage people, then are we really performing a public good?
Well, if you return us down to the Superior Court on an even footing, where we are going to start this evidentiary process one more time, with this actually a two-sided process instead of one-sided this time, I think we're going to be able to work this out in advance of that even. But if not, then she will have her day in court, which she hasn't had yet.
Well, I would encourage you to try to work it out before lunch today, but
Well, I'd like to do that. As you know, reason is my middle name. There was one point I hope to make, if I may, indulge with the court's indulgence. It's very small. My colleague, I think, misunderstood the facts when he talked about the March 24 hearing. At the hearing itself, the Superior Court explained that these phone calls had been made, there had been a request for a telephone conference, and the trial judge denied that. And it's on the record in the transcript for the March 24, 2017 hearing.
Understood.
Your Honors, I appreciate the extra time. Thank you very much.
thank you.
And for your wise words.
Folks, a word to the wise.
Yes, sir.
We're adjourned.